recently talked about a huge win in the Ninth Circuit Court of Appeals in California when that court ruled that the Second Amendment protected the right to keep and bear arms of 18 to 20-year-old young adults. But some of you have said in the comments something along the lines of, "Hey, Mark, this is only a temporary win, right?" Well, is it? Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, best-selling author, and proud American gun owner. If you have not yet subscribed, please do so to show your support for a fellow gun owner and the Second Amendment. For those of you familiar with the Ninth Circuit Court of Appeals, or the Ninth Circus Court of Appeals, some of you might say, out there in California, when it comes to the Second Amendment, I'm going to get into some inside baseball of what may happen with this case of Jones, which involved a panel of 3 judges who concluded that the Second Amendment protects the right to keep and bear arms of 18 to 20-year-olds when it comes to buying center-fire rifles in the state of California. As you may recall, we did a video here a couple weeks ago about how the Ninth Circuit held that 18-year-olds to 20-year-olds have a constitutional right under the Second Amendment based on the text of the Second Amendment, the history of the Second Amendment, and the traditions associated with gun ownership in the United States. Now, many of you have pointed out correctly, and I applaud this, that, hey, Mark, this is the Ninth Circuit Court of Appeals in California. They often have a panel decision of 3 judges that rule in favor of the Second Amendment. They rule in favor of gun owners. And then what happens is the Ninth Circuit basically comes together as a whole, meaning all the judges or most of the judges get together and do something called an en banc review of the panel decision. Now, many of you have said, hey, Mark, isn't this panel decision really just temporary? Because even though the 3 judges in the Ninth Circuit have found that the Second Amendment protects this right for 18 to 20-year-olds, isn't the Ninth Circuit Court of Appeals in total, or at least most of the judges, going to come together with an en banc review and basically overturn this panel decision, hurting gun owners in the Second Amendment? Well, I applaud you for making this observation, but I want to tell you 2 reasons why I think in this particular instance, there's a very good chance that the Ninth Circuit Court of Appeal will not try to do an en banc review of this Jones decision in favor of our gun rights. There's 2 reasons why I think this is the case. First of all, think about this strategically. The last thing that the anti-gun community in the United States wants is for the United States Supreme Court, which is the law of the land, to issue a ruling that says 18 to 20-year-olds have the right to keep and bear arms under the Second Amendment, because the anti-gunners want to do everything in their power to prevent the Supreme Court from issuing any pro-gun, pro-Second Amendment rulings. And if the Supreme Court were to hear a case involving 18 to 20-year-olds and their gun rights, whether or not the Second Amendment protected them, there's an excellent chance that this Supreme Court, as it's currently constituted, would conclude based on originalism that absolutely, not only did 18 to 20-year-olds have a right to keep and bear arms, at the founding, which is the relevant time period, they were actually required to keep arms because they had to have private arms and private ammunition in their homes so they could bring it out for militia duty, and they were required to bring this weaponry. So how can you say they weren't allowed to, at the age of 18 to 20, have guns and ammunition in the home under the Second Amendment when they actually not just could have it, they actually were required to do so for militia duty at the time? But more importantly, I want to tell you why I think that the anti-gunners are not going to seek to do a rehearing en banc in the Ninth Circuit. It's because it's going to bite them in the butt. And I think they know this, and here's why. Right now, the gun rights groups have won in the Ninth Circuit, which means that sort of narrow law dealing with center-fire rifles and 18 to 20-year-olds being able to acquire these has been sort of limited, right? There's a ruling on there that 18 to 20-year-olds can have the Second Amendment rights. But here's the thing. That right now only applies to the states in the Ninth Circuit, which are a lot of states, including California. The anti-gunners don't like this. But here is what they would hate worse. If the anti-gunners and the state of California, which is part of the anti-gun community as I see it, so if the anti-gunners petitioned the Ninth Circuit in total to have a en banc hearing, which basically means the entire court comes together and oversees and takes a look at what the panel of 3 judges decide to see if they agree with it. And then let's say the en banc panel, the big panel of all the justices in the Ninth Circuit, actually overturned the panel and says, no, 18 to 20-year-olds have no Second Amendment rights under the Second Amendment. That's not how it works. We disagree. We overturn it. Guess why that's a terrible outcome for the anti-gunners? It's because it now allows the gun rights plaintiffs in the case to seek review from, guess whom? The U.S. Supreme Court. It actually allows the gun rights groups to have standing to go to the Supreme Court and say, dear Supreme Court, we lost in the Ninth Circuit. We think this is wrong. 18 to 20-year-olds should have the right to keep and bear arms. And we want you, the Supreme Court, to reverse this and make it clear for all of America. So I think that's why there's a good chance that the anti-gunners may strategically decide that while they're unhappy that this one panel upheld the rights to keep and bear arms for 18 to 20-year-olds, I think there's a very good chance they're going to be like, look, we don't want to mess with this. Because yes, this is a battle we've lost. But if we en banc it and get it all reversed, guess what? We're going to let the gun rights plaintiffs have the ability to go to what may very well be a Second Amendment friendly Supreme Court and issue a ruling that would not just apply to California and not just to the Ninth Circuit, but to all of America. And they won't want that at all. That's why I think there's a very good chance that the Ninth Circuit Court of Appeals will not hear this case en banc and do what they usually do, which is to overturn the panel decision in favor of the Second Amendment. Now, there's a second reason, and this is a very interesting historical thing for you historical geeks out there, because this, I think, this story I'm about to tell you is likely why Merrick Garland, who you remember, he's now the Attorney General of the United States under Joe Biden, but you may remember that Merrick Garland was nominated to replace Justice Scalia after Justice Scalia passed away. He was nominated by Barack Obama in 2016, but he never had a hearing because that was in 2016. Mitch McConnell and Chuck Grassley, the Republicans in the Senate, says, hey, traditionally, we don't allow for there to be a hearing where the president and the Senate are controlled by different parties. It's like a tie. And in that situation, we're going to let the American people decide in November of 2016 who they want to control the Senate, who they want to be the president. And we know what happened there, which is that Merrick Garland's nomination by Barack Obama expired when Donald Trump was elected president and the Senate was controlled by the Republicans after the 2016 elections. But here's what you may not remember or may not recall from the Merrick Garland battle. Because Merrick Garland was a judge on the D.C. Circuit when he was nominated to be the replacement on the Supreme Court for Justice Scalia's seat. Here's what you may not recall, but is very important. You see, you may remember the Heller versus the District of Columbia case. We've talked about it a lot. That's the 2008 decision by the U.S. Supreme Court that said that you have a right to a loaded handgun unlocked in your home under the Second Amendment in anticipation of things like self-defense uses. But did you know that the District of Columbia versus Heller case, before it was Heller, was actually, of course, heard by the D.C. Circuit? Now, the D.C. Circuit actually held that the Second Amendment did protect the right to have a handgun in the home and that the District of Columbia's law was unconstitutional. So what happened there, and this is very important to understand, the District of Columbia's lawyers, rather than seeking cert from the Supreme Court immediately in the Heller case, which actually had a different title there called Parker, but that's neither here nor there. What happened in that case was the District of Columbia's lawyers decided to seek en banc review of the Heller decision in the D.C. Circuit. They wanted the whole D.C. Circuit to hear the Second Amendment question presented to that panel of 3 judges that said you had a Second Amendment right to a handgun. And what happened was the entire D.C. Circuit in total did not vote to take the case en banc. They actually voted against to take the case en banc. But here's where Merrick Garland came in and likely what sunk or put the nail in the coffin of his nomination to the Supreme Court. Who was one of the judges that was on the D.C. Circuit at the time when the Heller case was in the D.C. Circuit before it got to the Supreme Court? Who was the name of one of those judges that voted to hear the case en banc, presumably to take that panel decision in favor of the Second Amendment and reverse it and make it anti-Second Amendment, to say that the Second Amendment did not protect individual rights? Who was one of those judges that voted to hear the case en banc to probably reverse that panel decision in favor of the Second Amendment? That judge's name was Merrick Garland. That's right. Merrick Garland, although he may have a disagreement as to why he voted this way, but the reality is he wanted to hear that panel decision in the District of Columbia versus Heller en banc, presumably so he and the rest of his judges could rule against the Second Amendment and say there was no Second Amendment individual right, it was a collective right. That's presumably or apparently what he likely was suggesting when he said he wanted to hear the case en banc. The reason why this is important to the Ninth Circuit case is because there's a lot of judges on that Ninth Circuit right now that I'm betting you dollars to donuts. They want to, if they can, given their career path, they would love to be on the United States Supreme Court. And if they're smart, and I assure you, if they're Court of Appeals judges, they're smart. And they're savvy when it comes to their careers and their futures. I'm telling you, they know the story of how Merrick Garland voted to hear the Second Amendment case en banc and was overridden, and that was used against him when the question became whether the Senate should confirm Merrick Garland, and the answer was undeniably no, among other reasons because it looked like he was bad on the Second Amendment. Those judges in the Ninth Circuit are aware of the story of Merrick Garland, and I'm also guessing that they're thinking, better to let sleeping dogs lie. Let this panel decision stand, and we'll deal with it in other ways, but we won't en banc it because of all the possible backfiring that occur both personally and professionally for the judges, as well as policy-wise for the anti-gun movement if the Ninth Circuit decision of 18 to 20-year-olds having the right to keep and bear arms is extended to the whole country by virtue of a Supreme Court decision that could occur if they en banc it and reverse this decision. Okay, I hope you learned something here today at the Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.